So the next topic we looked at was about capacity and agents of the company. And capacity is a legal question for human beings as much as it is for companies. And for human beings, we limit capacity depending on age. We can also limit capacity because of someone's mental health. We used to limit capacity for women in Victorian times and for slaves in Roman law. So that's ascribing to someone the ability to be a party to a contract. So sort of personal legal quality. It used to be that the company's capacity was limited and it was limited to objects. And transactions that weren't within the objects were considered to be void. And that is something that didn't work. I won't say very much now because by now you know how capacity works. But this idea of saying this company is incorporated to run a certain business, for example, like lending deck chairs for a festival, and then the festival ends, and then the company stops being able to do anything because its purpose is gone. So that wasn't very useful. And here are examples. Or here's so that's sort of the critique of the ultra vires doctrine. There is another doctrine which is called the constructive notice doctrine, and that doctrine was sort of established in Ernest and Nichols, and that doctrine says that the articles of association are a public document, and therefore third parties are presumed to know what is in it. And that doctrine is necessary to give effect to the ultra vires doctrine. So you say companies can only contract for a certain purpose for which they were incorporated. Plus, if they step outside this, contracts are void because a third party is presumed to know that the company has this limitation because they're presumed to know the objects are limited. I won't say very much about this slide because I no longer need to introduce you to the ultra vires doctrine. Now, what's the Position Companies Act 2006? The memorandum states the intention to form a company. The company's constitution consists of the articles plus any resolutions amending it. The company's articles regulate the rules for the company, their model articles, and a statement of object is no longer necessary. But even if there is one, Section 39 says that the validity of an act done by the company shall not be called into question on the grounds of lack of capacity by reason of anything in the company's constitution. So there it is. The external effect of the ultra vires doctrine is gone. It remains relevant in two ways, and two of them actually, you are now familiar with. It continues to operate for charities. It continues that there are special rules for transactions involving directors, plus the object clause binds directors. So they have a duty, Section 171 sets this out, to obey what the articles say. And if the articles are too limited for their liking, well, they need to talk to the shareholders so that the shareholders amend the articles. And sometimes also an action in contravention of the objects of a company or the purpose of a company can justify a disqualification. So Section 171 says the articles are relevant, but only internally. So directors get in trouble if they step outside what the articles say, but a third party doesn't care because the validity of an act done by the company shall not be called into question on the ground of lack of capacity by reason of anything in the company's constitution. Okay, so then we talk about so what International Sales and Marcus says, but we don't need to go into that detail now. Let's move on to agency. So we have covered, and we can put to side the question, does the company have capacity? Its capacity is now unlimited towards third parties. Now the next question which follows on is, who acts on behalf of the company? So if someone signs a contract in the name of the company, two questions arise. One is, have they been validly appointed? Second one, what is the scope of their power? And here we open a wide field which we're going to discuss now. So this doctrine of constructive notice, this idea that a third party is presumed to have read and understood the articles, had implications for the ultra vires doctrine, but it also had implications dealing with the authority of agents. But now that's no longer the case, because a person dealing with a company is not bound to inquire as to any limitations of the power of the directors to bind the company or authorize others to do so. So for the power of the directors, and I've highlighted this word, and I'll come back to why I've done that, the limitations in the articles are not, so a third party doesn't have to inquire about those. Now the constructive notice doctrine is very old. Ernest and Nichol was decided in the 19th century, and then along came a case called Turquant, where the assumption was the third party knows that the directors only can do something under the articles if the shareholders agree. And so what's the third party to do is the question. Do they have to conclude, too bad, the director has no authority? Or can they conclude, well, probably all's fine? Or do they need to inquire what happened internally? Now, Royal British Bank and Turquant held they can assume everything's fine unless they have been put on inquiry. So the position is third parties needed to read the articles, and if there is an internal step that needs to be completed for the directors to sign a contract, they don't have to do more than note that and say, okay, well, internal step necessary, but don't have to inquire further. So that's the indoor management rule. That rule also applied in relation to whether someone had been formally appointed, which is a separate thing, because that's the question of not do they have the power, or what is the scope of their authority. That's a question of should they even be there. Are they even validly a member of the board? Now, for that, we've got a special provision, section 161, and that has to do with the validity of the acts of a director. And the director the acts are considered valid even if there's some defects set out in section 161. Okay, now talking about scope of authority and the authority of directors, there are three ways in which authority can arise. One is express actual authority. The other one is implied actual authority, also known as usual authority. And apparent authority is the third one, also known as ostensible authority. The landmark case is Freeman and Lockyer against Buckhurst. And those distinctions are set out in that case. Now then, you remember we discussed examples of actual authority, and we did that in the context, in our own context, in the context of LSE, and we concluded that I have actual authority to sign a reference. Mandy, the administrator, has actual authority to buy stationery for our department. Some members of the IT department have actual authority to buy computers and other devices for academics within the school. And the director of the school, Minouche Shafiq, does she have authority to sell the new academic building? Answer, probably not. She would have to go to some internal body to approve such a transaction. So actual authority is something you find in my contract or in the terms of my employment. So that would be the combination of the contract I signed when I first joined plus the staff handbook, which sets out what my job is. So that would be an actual document which says, and academic members of the department are responsible for writing references. And this is the point at which I get actual authority in that staff handbook. Now then there is usual or implied actual authority. So that is something that comes with a particular job. So let's look, for example, at Mandy, our administrator, who does the ordering of the stationery. That may be set out in the staff handbook, but possibly not, because she's an administrator, she was hired, there's a general handbook for administrators that doesn't really specify what kind of role someone has. So, but she still has implied actual authority because she was appointed to the position of managing the supplies of stationery for the law department. So her authority is implied from the fact that she has a particular job. So that would be in the authorities Healy, Hutchinson, and Brayhead. So I think I've just explained the difference between implied actual authority and actual authority. Now going back to the types, looking at express actual authority, implied actual authority, and apparent authority. Now then, we looked at people acting for the company, and you can see how for these roles that are now on the slide, you would define different job profiles. Board of directors probably can sell the new academic building. Chair of the board, probably not. The managing director can probably also not sell a building. Individual directors, definitely not. Then there are chairs of board committees, for example, remuneration committee, company secretary, which is a position of as an administrator. And then you get branch managers. So the bank branch near the LSE, or you get someone who sits in a call center who is responsible for communicating decisions. So you can see that with all these groups, you can imagine what their actual authority is. Plus, you've got some life experience, certainly for branch managers and those responsible for communicating decisions in a call center, to form a view on what their implied authority is, what it is that usually comes with their role. So we've looked at actual and usual authority. I won't go into that any further, but I'll move on to ostensible authority. Now, ostensible authority is also a form of authority that has to do with someone having stepped outside of what they normally do, but the company is still bound because, let me just look at that. So in Castles, there was no ostensible authority. Let me find a case where there was yeah, actually the sort of, let me go back. Freeman and Buckhurst. Freeman and Lockyer against Buckhurst was such a case where one of the directors had taken it, so was charged with selling some property, and that didn't go as planned. And then he went on to instruct some architects and to develop the property with a view to selling it later, but now in a developed form. And the company was bound to this contract with the architects because they had held this one director out as being responsible and having a power to act on behalf of the company. So apparent authority occurs when you've got a representation by someone who had authority, in that case the board, and they had actual authority, and they had caused the business to be conducted in a way that sent a signal to the third party, and that signal is called a representation. And the third party receiving that signal couldn't help but conclude that this single director had this authority because everything pointed that way. Not because it was usually the case, that's not true, it wasn't usually that case, but in the context of this transaction, signals were sent and received by the third party, which allowed them to conclude that there was a power of this one particular director to make a contract with the architects. So then let's go here to ostensible authority. And here's an example where there's no such ostensible authority. Now here's a case which then looks at this question of authority can be an authority to communicate. First Energy and Hungarian International Bank, where a senior branch manager didn't have authority to decide, but he did have authority to communicate someone else's decision. So that's, I think, a really important case, because a lot of our interactions with companies and with businesses isn't through we never really speak to a decision maker, but we often speak to people who say, I'll find out for you, and then they come back and tell us, I've been told this is the case. Well, they are messengers, and they have the authority to communicate, so the company is bound, not because they gave them the power to decide, but because they gave them the power to communicate someone else's decision. Okay, so let's look at the next one. So previous dealings that the company had can also create ostensible authority. Or in the Eversheds case, the chair of a remuneration committee was held out by the board to have authority to hire solicitors. So what you need is this holding out. It's not normal for a chair of a remuneration committee to hire solicitors, but in the circumstances, the sort of the interactions with the firm, with Eversheds, led them to believe that there was, in this special case, authority. And here's an example where ostensible authority does not reach as far as a manager having the authority to request payment without explanation to his wife. Okay, I think I'll skip those special cases. Yeah, so this is we need to look at this one. Ostensible authority, how is it different from actual? The key difference is, for ostensible authority, you need a holding out, a representation by someone with authority plus reliance. So you need to test three things. Was there a representation by someone with authority, and did the third party rely? For implied actual authority, you don't need that. For implied actual authority, you need to say, okay, Mandy was appointed to the position of ordering stationery. That means she can go online to the supply company and, or rather call the supply company and get them to send us some pens. That's all you need to do. You need to work out what's the position. That's an act of interpreting the role they have been appointed. She has been appointed to. So you don't need to show that there were any prior dealings. There was a communication earlier with this supply company. Nothing. All you need to show is she has been appointed to the role of an administrator, able to order pens. Now, let's then go to examples of actual authority. The directors for Section 40. Section 40 says, the authority of the directors to bind the company or authorize others to do so are free of any limitation. So in a problem question, when the whole board acts, you can go straight to Section 40 saying company is bound because the directors have acted. Note that what that means isn't quite clear. It's clear that if the whole board acts, Section 40 applies. It's also clear that if just one director acts, probably not. But what happens if the board isn't quite quorate? We don't really know, but probably the section applies. And here are examples of sort of interpreting Section 40. I won't go through them. These are examples when Section 40 doesn't apply. You can do this in your own time. Okay, summary then. I'll talk through that. The companies have unlimited capacity. Directors, with the question of what does that mean? How broad is that? Have unlimited power to bind the company and authorize agents towards third parties in good faith. A third party is not bound to inquire as to the limitations of the powers of the directors. The authority of a company secretary, branch managers, and other individuals are governed by the common law. What's the common law? Agency principles. Authority can be actual, express, actual, implied, or apparent / ostensible. The constructive notice doctrine is abolished, but only for the power of the directors. In relation to other agents, it is mostly irrelevant. And I think we leave it there. So that is companies being bound by their agents to act, to become a party to a contract.